The letter is 2 paragraphs long. It thanks you for contacting them. It says they have completed their investigation. And then it says the sentence that ends the conversation. We determined that no error occurred. Underneath it, in smaller type, is a case number and a closing date. That is it. Your money is gone, you did what you were told to do, you reported it, and the institution that holds your account has decided, on its own, that nothing went wrong. Most people read that letter twice and then put it in a drawer. They assume it is final because it looks final. It is written to look final. Here is what I want you to understand in the next 12 minutes. That letter is not the end of the process. It is a step in a process that federal law defines, that has deadlines the bank was already bound by, and that gives you one specific thing you can ask for in a single sentence. Almost nobody asks for it, because almost nobody knows it exists. And asking costs you nothing. Before we get to what you can do, you need to know what the bank was already required to do, because that is the ground everything else stands on. When you tell your bank about an unauthorized electronic transfer, the rule is Regulation E, and it is not vague. The bank must investigate promptly and determine whether an error occurred within 10 business days of receiving your notice. 10, not 30, not whenever they get to it. Now, the bank is allowed to take longer. It may take up to 45 days instead. But there is a price for that extension, and this is the part that gets skipped. To take the longer window, the bank must provisionally credit the money back to your account within those same 10 business days, and it must give you full use of those funds while it investigates. So, if your bank told you the investigation would take weeks and your balance never moved, one of two things is true. Either they finished inside 10 business days, or they took the extension without meeting its condition. Both of those are worth writing down. Read the refusal letter again and find the word that is doing all the work. Usually it is authorized. The transaction was authorized. You authorized the payment. And once that word is on the page, most people stop because it sounds like a finding of fact. It is not. It is the bank's conclusion, reached by the bank, reviewing the bank's own records. That is not a criticism, it is literally what the rule permits. Regulation E says that in certain cases, where the transfer went to a third party and there is no agreement between your bank and that third party, the bank reviewing its own records satisfies its investigation obligation. So when the letter says we investigated, that can mean a person looked at a screen showing that the correct card number and the correct code were used and closed the file. It does not mean anybody asked how the details got there, or whether you were talked into entering them, or whether the pattern looked like every other case that month. Those are questions the documents would answer, which is exactly why you are going to ask for the documents. There is a clock, and it is the one thing in this video that can defeat you no matter how right you are, so I want it clear before we go further. For an unauthorized transfer that shows up on your statement, you have 60 days from the day the bank sent that statement to report it. Inside that window, your exposure is capped. Tell them within 2 business days of learning your card or access device was lost or stolen, and the most you can be liable for is $50. Wait longer than 2 business days, and the ceiling rises to $500. But let 60 days pass from the statement, and for the transfers that happen after that, there is no ceiling at all. That is not a penalty the bank chose. It is written into the rule. There is one relief valve, and it is worth knowing. If your delay was caused by extenuating circumstances, the regulation says the institution shall extend the time to a reasonable period. Shall, not may. If you were in hospital or caring for someone or away, say so in writing, and say what the circumstance was. So here is the sentence, and it is the reason this video exists. When the bank decides that no error occurred, Regulation E does not just let it send you a refusal. It requires the bank's report to include a written explanation of its findings, and it requires that report to note your right to request the documents the institution relied on in making its determination. And then it says that upon request, the institution shall promptly provide copies of those documents. Read that again. Not may provide, shall promptly provide. So the sentence you write back is this. Please send me copies of all documents you relied on in making this determination, as provided under 12 CFR 1005.11, Section D. That is the whole thing. You are not arguing. You are not appealing yet. You are not asking them to reconsider. You are exercising a right that the same rule which let them refuse you also gives you. And if you hold a credit card rather than a debit card, there is a matching provision, and I will come to it in a moment, because the credit card version is stronger. Why does that request change anything? Because a decision nobody has to show their work for is very easy to make, and a decision that has to arrive with its file attached is a different kind of decision. When the documents come, you are looking for a small number of things. What exactly did the bank rely on to conclude you authorized this? Is it a log showing your card details were used, or is it something that actually connects to you? Does the file contain any record of contact with the merchant, or with the receiving institution, or is it only your own bank's internal notes? Is there a timeline, and does the timeline match what you told them? And here is the one that matters most, and I want to be careful how I say it, because I cannot tell you what will be in your file. Sometimes the answer is that the file is very thin. If a bank has to send you 3 lines and a screenshot, that tells you something about how much investigating there was. And it gives you something specific to point at when you go to the next stage. If the money went out on a credit card rather than a debit card, you are under a different law, and it is a stronger one. It is called Regulation Z, and it covers what it calls billing errors, which includes a charge on your statement that was not made by you or by anyone authorized to use your account. Here is what it requires. The creditor must acknowledge your dispute in writing within 30 days. It must resolve the dispute within 2 complete billing cycles and never later than 90 days. And if it decides no billing error occurred, it must send you an explanation, and it must furnish copies of documentary evidence of the debt if you ask. Same lever, different statute. But now the trap, and this one costs people their entire claim. Under Regulation Z, the dispute has to be in writing, and it has to go to the specific address the card issuer discloses for billing errors, not the customer service number on the back of the card. A phone call does not start this clock. It has to arrive within 60 days of the first statement showing the charge. If you have only ever phoned, you have not disputed it yet, in the sense the law means. While a credit card dispute is open, there are 4 things the card issuer is not allowed to do, and knowing them is what stops a dispute from turning into a second problem on top of the first. It may not try to collect the disputed amount, and you do not have to pay it. It may not report you as delinquent to any credit bureau over that amount, and it may not threaten to. It may not close or restrict your account or accelerate the debt, simply because you exercised these rights in good faith. And if your card is on automatic payment from your bank account, it may not deduct the disputed amount, provided your notice reaches them at least 3 business days before the scheduled payment date. That last one is the one people miss, and it is why the timing of your letter matters as much as its contents. If you are 3 days out from an auto-pay date, that is today's task. None of this makes the charge disappear. It stops the charge from damaging your credit and draining your account, while the question of who owes it is still open. Now, what if you ask for the documents, you read them, you write back, and the bank still says no? Then you go above the bank, and this is the part most people never reach, because they assume the bank is the last word on the bank. It is not. In the United States, the Consumer Financial Protection Bureau takes complaints about banks and card issuers directly from consumers, and it forwards them to the institution with an expectation of a substantive response. It is free. You do not need a lawyer, and you do not need to have done anything special first, although arriving with the bank's own documents in hand makes your complaint a great deal harder to wave away. If you are watching this outside the United States, the same structure exists with a different name. In the United Kingdom, it is the Financial Ombudsman Service, set up by Parliament, and it is free to consumers. In Canada, it is OBSI, the Ombudsman for Banking Services and Investments. In Australia, it is AFCA, the Australian Financial Complaints Authority, also free. Different countries, same shape, there is a body above your bank, and it costs you nothing to use it. So here is the order if you are sitting with a refusal letter right now. First, check the date on the statement where the charge first appeared and count 60 days forward. That single number tells you whether you are still inside the window or arguing about extenuating circumstances. Second, write, do not phone. If it was a credit card, send it to the billing errors address printed on your statement, not the service number. Keep a copy of what you sent and the date you sent it. Third, in that letter, ask for the documents. One sentence, please send me copies of all documents you relied on in making this determination. Fourth, when the documents arrive, or when they do not, file with the Consumer Financial Protection Bureau at consumerfinance.gov, and attach what the bank sent you along with what you asked for. And if you are on auto pay and a payment date is close, send the letter today rather than tomorrow, so the 3-business-day rule protects you. Now the honest part, because I would rather you hear it from me than find it out later. None of this guarantees you get your money back. Asking for the documents does not oblige the bank to change its answer. It obliges the bank to show you what it used, and that is genuinely worth having, but it is not a refund. Some claims fail because the transfer really was authorized, even if the person was tricked into authorizing it, and the rules on that are narrower than most people expect. And the deadlines cut both ways. The same 60-day clock that protects you when you act quickly will defeat a completely truthful claim if you let it run out. That is why the first thing in the previous section was the date, not the letter. If you take one thing from the last minute of this video, take the deadline, not the sentence. The sentence is what you use inside the window. The window is what you cannot get back. So, everything in one place. That refusal letter is a step, not an ending. The bank had 10 business days to decide, and it could only take 45 if it gave you the money back provisionally while it looked. You have 60 days from the statement to report an unauthorized transfer, and after that the cap on what you can lose disappears. On a credit card, you must dispute in writing to the billing error's address, and while it is open, they cannot collect, cannot report you delinquent, cannot close the account, and cannot take the disputed amount by auto pay. And then the one rule, the thing to take with you if you take nothing else. When the bank says no, write back and ask for the documents it relied on. That is a right in the same regulation that let them refuse you. It is one sentence long, it costs nothing, and it turns a decision nobody had to justify into one they do. Everything in this video is published federal rule, not legal advice. If this was useful, send it to one person who has ever been told no by a bank.